Well, the answer to that question actually depends on where you were when the accident happened. So, if you were in North Carolina, for example, North Carolina is one of the few jurisdictions that still follows what they call the contributory negligence doctrine, which basically means if the plaintiff is even 1% at fault, they're barred. Now, with that said, it can be difficult, very difficult for a defendant to prove that the plaintiff was contributory negligent. But if they do, then you're completely barred. If, however, you're in South Carolina when that happens, South Carolina follows a comparative negligence scheme whereby they just take the percentages of fault. And let's say if you had a $100,000 verdict and you're deemed to be 40% at fault, you get to recover the 60% of the 100,000. So it's a comparative negligence situation versus, again, in North Carolina, it's contributory negligence, which if you're at fault at all, it would bar your claim. But again, that's a doctrine that can be difficult for a defendant to invoke. So key point, talk to an attorney, call us. We'll be glad to talk to you about what happened, whether or not we think there's a good defense, what the defenses may be, and we can go from there.